Hi, everybody. This is Jennifer Schaus coming to you live from Washington, D.C. in our Government Contractors Q&A Cafe. These webinars are the second Friday of each month, and they run about an hour and a half. We've got various subject matter experts and attorneys covering one topic for each webinar. Everything will be recorded today, so if you have paid for attendance, you'll receive the MP4. And all the PowerPoints are available to anybody with an internet connection over at slideshare.net. In January, we covered CMMC. Last month was OTAs. You can find those on our website. Today, obviously, we're covering bid protests, and you can see the schedule here for the rest of the year. Again, these are the second Friday of every month. All of the registration links are on our website under the Q&A Cafe tab. A little bit about us. We do provide consulting services for federal contractors, including product, software, and services firms. And our services range from market analysis reports to proposal writing, compliance, and GSA schedules. A little bit more about us is on our website under the About Us or Services section. So as I mentioned, today we're going to cover bid protest. And we want to thank our speakers for joining us. One in particular, Mary Beth Bosco, who actually retired last month, so she has come out of retirement to participate here today. So thank you, Mary Beth, for joining us. Also, we've got Ed Delisle, who has joined us as well, and he speaks frequently in our webinar series, as does Mary Beth, and Josh, and also our next speaker, Elizabeth. So thanks, Joshua from Mattress Edwards and Elizabeth Jokum from Smith Patcher McWater PLC. Okay, so as I mentioned, we'll cut to the chase here and start covering our topic, which is bid protest. And over to you, Ed. Just let me know when you're ready for your next slide.
Okay, thank you, and thank you everyone for joining this afternoon. Yes, it's now afternoon. So our topic today is bid protests, and we'll start at sort of a 30,000-foot level and work our way down into the weeds as we sort of progress through our discussion today. Since I'm going first, I'll sort of set the stage and lay the foundation for the rest of the discussion. When we talk about bid protests, we're talking about the right to challenge the rules of a procurement, the terms of a solicitation. That's sort of one group, and we'll talk about what that means in more detail momentarily. And we're talking about the right to challenge a proposed evaluation or an award, which is sort of a separate group unto itself, and we'll talk about that as we progress through our discussion today. It's important to understand in the federal procurement process, if you want to protest either the rules of a procurement or a proposal, evaluation, or an award, that you understand that to do so, the process itself is governed by statute and/or regulation. And for the most part, when we talk about bid protests, we talk about, and we want to talk about the rules, we talk about regulation. Specifically, FAR Part 33, which is entitled Protest, Disputes, and Appeals, is where you generally will want to look to better understand how to protest and what's involved in a protest. You can also look to DFAR Part 233, which is the Department of Defense's supplement to the FAR. There are some supplementary regulations there that someone who's interested in protesting will want to review if you were talking about a DoD opportunity. But generally speaking, what we'll be talking about today will fall within the purview of FAR Part 33. The whole point of protesting is to provide an opportunity to ensure a fair and objective procurement process. That sort of goes without saying. Now, I will say that the whole point of protesting, that is to ensure a fair and objective procurement process, has sort of been challenged or pared down through congressional action over the years, particularly or specifically as it pertains to the ability to challenge task order awards through IDIQ contracts, which has become more and more popular over the years. But be that as it may, you still find protests being filed all the time, and I'll say that I believe that it is a certainly a way to ensure that you have an objective process moving forward and to keep the government honest to a certain extent and make sure that they do their job. When it comes to protesting, the thing to really understand is that the process is rule driven. And in order to go through this process successfully, you do need to understand the rules, and we're going to go through many of those rules as we progress through our discussion this afternoon. Okay, if we can advance the slide. Okay, so I mentioned a few moments ago that we have the same slide. Okay.
Oh, sorry.
There we go. There we go. I mentioned a few moments ago that there are two sort of different types of protests, and we'll talk about them a little bit more now. You have what we call a pre-award protest. And as part of a pre-award protest, what you would be attempting to do is challenge the terms of a solicitation or the ground rules that are identified as part of a competition within the solicitation documents. One of the cases that a lot of practitioners that operate in this field will refer to as the blue and gold case, or the blue and gold fleet case, as it pertains to pre-award versus post-award opportunities, and when you should challenge an award pre-award versus post-award. Blue and gold basically stands for the notion that if you have the ability to challenge the terms of a solicitation, if there is what the case refers to as a patent error in the terms of the solicitation, that you have a responsibility to do that before the submission of bids or proposals. And if you fail to do that, then you waive your ability to raise those issues later as part of a post-award protest. So if you don't like the rules of the competition, just understand that you have to challenge those before the submission of bids or proposals. What's interesting about that is it sounds easier than it really is. There was just a case that came out over the summer called Inserso Corporation, which was sort of a weird case where you had a competition where you had both a free and open and a small business pool, and you had the ability for companies to be in both, okay, to compete for both. It just so happened that the free and open competition, that pool was way ahead of the small business pool, and as a result of that, there was information that came out during the debriefing process on the full and open, where you had some of the small businesses that were competing, that they were able to take advantage of as part of the subsequent small business competition. And Inserso, the company that challenged the results of the award on the small, it only ended up competing for the small award. They said, well, hey, look, because the free and open was so far ahead of what was happening in the small business pool, the companies that took part in that, well, they had an advantage over the information they received as part of the debriefing process there, and that hurt me because I didn't do that. Well, this one went all the way up to the federal circuit, and basically what the federal circuit said was, well, you kind of should have known that this could have happened ahead of time. Can't challenge it now after the fact. You should have challenged the actual terms of the solicitation itself. Sorry. So in a case like that, it wouldn't seem as if the company that was challenging the result after the fact should have known that, at least to me. But what it does point out is the fact that you have to very carefully understand when to protest. We're going to talk about some of the time parameters associated with when to protest as we get further into our discussion. But just understand that it's really important to understand the difference between pre-award and post-award, and specifically whether or not you have the ability to challenge the terms of a solicitation ahead of time, because if you don't do that, then you can waive your ability to challenge the result at some point later. When we talk about post-award challenges, Generally speaking, you're talking about the evaluation process itself and challenging what the government has done as part of the selection process. Timing is very important with respect to that, and we'll get into some of the timing associated with post-award challenges as we go through the discussion this afternoon. And some protests don't really fit into either of these pre-award or post-award boxes neatly or cleanly. Eliminating a company from a competitive range under FAR Part 15 is one example of that. If you have a two-step selection process through FAR Part 15 and you are eliminated as part of step 1, you have a right to a debriefing under a situation like that, assuming that it's under FAR Part 15. And while you're not challenging the solicitation terms itself and there's no award, through that process of challenging your elimination from the competitive range, that's a separate sort of protest. Again, it doesn't fit in necessarily the pre-award or the post-award box. So just understand that that's a potential challenge that might be available to you as part of a protest as well. All right, if we can advance the slide. Okay, so it's important to understand who can file, right? In order to file, generally speaking, you need to be what's called an interested party. And what you see here is the definition of interested party as set forth in FAR Part 33. It's an actual or prospective bidder or offeror whose direct economic interest would be affected by the award of the contract or failure to award the contract. The tricky part there really is the part that talks about direct economic interest. So basically what that refers to is in a post-award situation, are you in line for award? Do you have a chance to win? Just challenged a competition through Health and Human Services where my client was 6th out of 10 offerors. And this was something that we were concerned about, but our argument was that the process was so flawed that where we ended up in the pecking order was no indication as to where we should have been. And actually just yesterday, the agency took corrective action, but you have to be careful because you can also have to deal with motions to dismiss in situations like that if you don't have a direct economic interest or if the agency doesn't think that you do. So something to think about. In terms of where to file, generally speaking, you're going to have 3 options. You don't always have 3 options, but generally speaking, this is what's available to you. You can go to the agency. I can tell you I don't go there very often. It's the least expensive place to go generally, but it's also probably the least effective because you're going back to the agency that either issued the solicitation or made the award and asking for the agency itself to make a change or to do something. A little bit harder unless it's sort of an obvious error. You have the GAO. Okay, the GAO is probably the most popular place to go. The effectiveness rates at the GAO have gone up over the years, so it's a good place to go. And generally speaking, you're going to get justice within a set amount of time, and we'll get into that as we get into our discussion. As we get deeper into our discussion, you also have the option to go into the United States Court of Federal Claims, COPSI. A little more process involved here. You'll have a judge assigned to your case. It's probably a little bit more expensive than the others also, but sometimes you'll want a judge assigned to your case to hear your issues depending upon what they are. The one thing you do want to watch out for is, depending upon what agency you're talking about, that agency may not necessarily follow the FAR. And the United States Postal Service is one such agency. I have a protest pending with them as we speak. They have their own process where you lodge a disagreement and you follow their particular regulations. So you need to understand if you want to protest whether or not the agency that you're dealing with does in fact follow the FAR, FAR Part 33, or if it has its own processes and procedures that it uses for purposes of dealing with disagreements. All right, we can advance the slide. And debriefings. Jennifer, you're on mute.
Sorry, Josh, over to you. I think you're self-muted. If you can unmute, Josh.
Yeah, Josh, you're muted. If you hover right on your picture, you'll be able to unmute yourself.
Yeah. Oh, maybe he's going to call in. Oh, okay. There we go.
For some reason, the mute button was stuck here. Good afternoon, everyone. And sorry for the hiccup. As Ed was mentioning earlier, the bid protest process is fairly rigid in terms of a lot of the regulatory and rulemaking and timeliness requirements. And one of those things that sort of come up for prospective protesters is dealing with these things that we call debriefings, which many folks use as a colloquial term, but is actually a very specific item. And they're available under FAR Part 15 procurements and certain task or delivery orders that exceed 6 million, subject to FAR 16.505. Now, folks, and when I mention this colloquial debriefing thing, you might have a procurement that's conducted under subpart 8.4, like a supply schedule buy, and you might ask the contracting officer if you've lost the award for a debriefing, but in that situation, you'd be given what's known as a brief explanation. And the reason why that's important is because there's some interplay between the debriefing and the bid protest timeliness rules. And so when folks have received a notice of award, you have generally 3 days to ask for your debriefing. And what I tell folks is to expressly state that in your email. And one thing to consider is there's a 3-day window. And what folks sometimes do is they wait a little bit too long to request the debriefing, and they may make that request after the close of business on the 3rd business day. Now, under the FAR, anything that's filed is considered filed as of 4:30 p.m. local time on the date that it's due. And so unless otherwise indicated on an agency's website, you have until the 3rd business day, or 3rd day actually, not business day, 3rd day at 4:30 p.m. to request. But say, for example, your notice came on a Friday and you waited till the 3rd day, and you made your request at 5 o'clock that afternoon, GAO might say, well, even though you received a debriefing from the agency, it wasn't a required debriefing because you didn't meet that 3-day timeliness rule here. So that's something to be aware of. A protester has gotten tripped up by that 4:30 p.m. deadline. It was an interesting case that involved a NASA procurement, and part of their argument was NSA is open 24/7. But GAO did not agree with that and concluded that because there was no other notification on the website as to the agency's close of business, the FAR controlled, and that meant that the debriefing that the company received was technically not required under the FAR. Now, so why is that interesting? Well, as Ed mentioned, we have these protest deadlines, and one of the things that protesters like to have particularly when they go to the Government Accountability Office, is the idea of obtaining an automatic stay of performance under the Competition and Contracting Act. And so where a debriefing is timely requested, the contractor would have 5 days to protest. Now, I say that because technically the statute is written in such a way that you have either 10 days from award or 5 days from the date the debriefing is held, whichever is later. Every now and then you'll get a debriefing within that time, but you're going to get that 10 days no matter what. But if the debriefing pushes that 10-day mark past that time, you still have that 5 days from the date that the debriefing ends. And so folks should be wise to get clarification whenever they can as to when the debriefing ends. A lot of times now they're a PowerPoint presentation or a slide deck that you're sent, or just a 3 or 4 page document that's called the debriefing. In some instances, the debriefing might be on the phone or in person. Obviously, with COVID-19, you're not really having too many in-person things happening, but that's something to remember when you're dealing with debriefings. Now, in stepping back from those procedural sort of hiccups that come along, debriefings are really a powerful tool because it gives a contractor an opportunity to sort of not only build a relationship with the agency, even though that you're a loser, but the awardee can obviously ask for a debriefing, but it's also a way to get some information out of the agency. Under FAR Part 15, as I mentioned, we have the pre-award debriefing and the post-award debriefing, and there's a little bit difference between the two. Under FAR 15505E, for example, under pre-award debriefing, a company is going to be able to get an evaluation of the significant elements in your proposal, summary of the rationale, and the reasonable responses to relevant questions. Now, when we compare that to a post-award debriefing, it's a little bit more robust. You're going to get an evaluation of the significant weaknesses and deficiencies, if applicable. Those terms are defined in FAR 15001. The overall evaluated cost of price and technical rating of the awardee and the debriefed offeror, as well as the past performance of the debriefed offeror, an overall ranking if one is developed. And that might be interesting to what Ed was mentioning with respect to prejudice. If you have a ranking, which is not always developed, but if it is, it can give you an idea of any hiccups that might be you need to think about in terms of showing a substantial, for competitive prejudice, rather. A summary of the rationale for award, and if it's a commercial item procurement, the make and model of the item procured. And of course, reasonable responses to relevant questions about whether the solicitation or applicable laws and regulations were followed. So that's sort of a catch-all thing for debriefings under FAR Part 15506D. Now, when folks are heading into the briefing, it's wise to kind of remember these items and to plan accordingly. Obviously, I mentioned that you have these two types of debriefings, the pre and post award. Ed mentioned removal from competitive range. So if you're in a situation where you've been removed from competitive range, obviously you want to ask for a debriefing if it's under FAR Part 15. But one thing to remember in that type of scenario is to not delay until after award. If the government wants to delay the debriefing until after the award, let them do that on their own accord. But as a potential protester, you want to ask for the debriefing and say that you want it then. The reason that's important is because it can impact timeliness issues of protest if you voluntarily wait. And so we always counsel clients to ask for it, and if it's the government's decision to delay it, it's on their own accord. If we can go, one last thing about the debriefing I think is worth mentioning is to head into the debriefing prepared. Obviously, if you have an opportunity to bring someone with you, or if it's on the phone, have someone transcribe what's going on. The function of the debrief obviously isn't to challenge the agency or to explain why you should have won. I've seen companies sort of take that approach, and it only can cause the agency officials to sort of be guarded. If your entire objective is to get some information, you always try to keep it open-minded and kind of free-willing. After the debriefing is over, take that information and work with your LT, your leadership team, or your outside counsel to determine whether or not you think that there's any grounds for protest. And at the same time, the debriefing is an opportunity to build those relationships with agency personnel, so use that accordingly. So that's sort of a general overview of what folks should be thinking about heading into a debriefing. They're obviously a little bit more complex than what I just described today, but those are some of the procedural hiccups. If we can go to the next slide. One thing that we talk about with protest are some of the pleading requirements. Ed mentioned, you have the pre-award protest, and you have the post-award protest grounds. If you've been, an unsuccessful offeror and you want to challenge that, what are required for a contractor to sort of make their case, to plead their case? As Ed mentioned, if we turn to FAR 33103, those are the protests to the agency, and the agency level protests require protesters to include the name, address, fax, and telephone number of the protester, the solicitation or contract number, a detailed statement of the legal and factual grounds for the protest, any copies of relevant documents, a request for a ruling by the agency, and some other items. And so you can see that there's a little bit of procedural requirements that are necessary for a protester to meet. But if you're looking for an agency level protest, head to FAR 33103. Now in FAR 33104, we have protest to GAO, and we also have GAO's bid protest regulations at 4 CFR 21.1. And if you choose to go to the Government Accountability Office, one thing that changed over the last couple of years is no longer filing via email. We have now an electronic protest docketing system, so these filings are uploaded into that system. And GAO has a similar outline of what is required for protests, and that again requires a contract number, solicitation number, the agency, a detailed statement of factual grounds, elements that establish the timeliness. Now, as I mentioned earlier, when we have a debriefing, your timeliness may be under a FAR Part 15 debriefing would be indicated as the date that the briefing ended. And so that's something that folks need to think about. It's not overly complex, but what you're doing essentially is putting GAO and then essentially the agency on notice of why you're protesting. Protests can be filed without counsel, but that's something to be aware of, particularly with respect to protective orders, which I think we'll get into a little bit later. And finally, under the Court of Federal Claims, there's a slightly different procedure. We're in a federal court. Folks are required to file a pre-filing notice, which goes to the clerk of the court, the agency's contracting officer, the representative that is to handle the protest, as well as the Department of Justice. So that's one extra step that folks need to think about. And in terms of pleading requirements, for most protests, it's very similar to the agency and GAO, but in federal courts, we have a slightly different standard that's announced in a couple of cases, Twombly and Iqbal, and that's a plausibility requirement. Most protests don't get dismissed under 12b1. It's really an obscure area that you're trying to challenge that this would usually come up in, but folks should be aware of that. The form is not as prescriptive as what you would for CFR 21.1 or FAR 33103, but something that and protesters need to think about. In federal court, you obviously have an option to file pro se, but most often you're entering that arena with counsel. If we can go to the next slide. And one other aspect to the protest mechanism that I think may or may not be underused, it's hard to say, is this idea of intervention. And when we talk about intervening in a protest, at GAO and at the Court of Federal Claims, the awardee has a right to intervene, essentially. At the court, there's a permissive right and a mandatory right under Rule 24. But essentially, if you're the awardee, you have a demonstrated interest in the procurement, you have a right to participate in that protest. You may be active in that intervention, and you may be passive in that intervention. And why do I say that? Well, there may be instances where the agency doesn't want to make an argument, or you want to make an argument, and you want to put yourself forward to defend the award. When we're talking about confidential and proprietary information, if you don't intervene, you're essentially letting the agency dictate what they believe is competitively sensitive. Now, most proposals would be redacted and anything like that. But if you have any doubts as to that, you may want to, enter the protest with someone that can get underneath the protective order in order to look at those rights. And the other thing is to sort of monitor the protest and see what's happening. And the other side, besides the corrective action, it's a bullet that I didn't add, is, a lot of folks that are working at the government are heavily overworked, unfortunately, and they may receive a protest, and their initial thought may be to take corrective action, right? And as you, the intervener, steps in, you might be thinking to yourself, well, I don't want the agency to take corrective action. The award was valid. The agency followed the terms of the solicitation and procurement laws, and there's no reason to delay the award. So I think that we should basically defend this protest at GAO, for example, and have the Government Accountability Office come to a decision. If in the event that the agency determines that it wants to take corrective action, I have seen bid protests where interveners are able to sort of help shape the scope of the corrective action in a way that benefits the intervener. And they don't happen that often from what I can tell, but I've seen a couple cases that sort of indicate that that's what was happening. And so that's another advantage of participating in the protest as an intervener. You're the awardee, you want to protect the award, and obviously if you can avoid having corrective action taken, all the better. And so with that, I believe my 3 slide decks are over, and I'll pass it off to, I think, Mary Beth.
Mary Beth, you're muted.
I think you're self-muted.
Yeah,
There we go.
that mute
Okay.
button, I think I had the same problem, was kind of sticky. So where I'm talking about, what I'm going to be talking about, is picks up from what Josh talked about. You've had your debriefing, and now you need to make the decision, should I file a protest or not? One question that I think we all get frequently from clients is, if I protest, will the agency be mad at me? Will it hurt me competitively? And the answer to that is, in most cases, no. In fact, the agencies that buy the most stuff, like DoD on large procurements, they actually build in a protest period when they're looking at the schedule, for rolling out whatever the program is. You don't want to get the reputation of filing frivolous protests, and also because of the stay, awardees will tend to file protests on maybe more chancy grounds, because the stay will at least get them performance for another 3 months. And you don't want to get a reputation of that's what you do all the time as a matter of course, whether or not you've got a good protest. So, and the other thing to keep in mind when you're weighing that is that you haven't seen the administrative record yet, right? You have a whole lot less information than the agency does. All you really have is what was told to you in the debriefing. So I think based on that knowledge, the agencies also, even if you lose a protest, they understand, that you needed to file it to protect yourself. The best, the decision as to whether or not to file is, rarely black and white. In other words, we've got a slam dunk here. It's usually a bit more nuanced. The best, or the closest to black and white, would be protests that are centered on whether the agency followed its own procedure. So, for example, an easy one is the solicitation required the offerers to meet 5 mandatory criteria, and based on the information that you have so far, the agency didn't actually even evaluate mandatory criteria, meeting the mandatory criteria. So the agency failed to take a step. That's a protest that has a pretty good chance of winning. The harder ones are the ones that you see most often, which is that the disappointed offeror believes that the agency didn't come to the right conclusion in the technical evaluation, or there was an unreasonable price or cost evaluation. The hurdle to that is that the agency is accorded it's almost automatic that they are considered to have acted in good faith, number one, and GAO and the Court of Federal Claims will often defer to the agency's expertise. So if you're in an area of, discretion, the agency could have done this, but it didn't, or could have evaluated, could have given us a higher score, but it didn't. GAO and the Court of Federal Claims will normally say that's an issue for the agency. We're going to defer to their expertise. I think another thing that you need to keep in mind when you're making that go, no go decision is, what are the available remedies? So, for example, if the remedy is likely to be a recompete or a reevaluation, and you think that there's a good chance that, given the agency's history, if there's a reevaluation, you'll still lose. That sometimes keeps people from protesting. And also, in terms of the remedy, could it be something like a withdrawal of the solicitation? Does that help us or hurt us? I mean, we want to keep that solicitation out there rather than experience such a delay in being able to win this award. So I think that you've got to look at what you can possibly win, whether if you win something, it's a, sort of a Pyrrhic victory. And if you don't get the stay, for example, for whatever reason, GSA leases, for example, they don't have termination for convenience clauses. So the GAO basically takes the position that it has no authority to offer a recompete or a resolicitation because they, once the lease is awarded, it's awarded and the agency can't terminate it without breaching the contract. So you have to look at things like that. At the end of the day, if all I'm going to get is my bid and proposal costs, which is what happens in these types of protests where, you go all the way through, you win, but there's really no effective remedy, right? So that's something that you should keep in mind too. So I think the other thing is that, we normally tell folks that, look, if you've got a colorable basis for protesting, there's no harm in filing a protest because, again, you don't have the record, so you don't have all the information. But then once the record comes in, what we will typically do is give it a, sort of a once over and then go back to a client and say, subject to the strictures of the protective order, you know what? There's no way you can win this because, the documentation is just spot on. Or we'll say, yes, let's keep going. And the other thing to keep in mind is that once you get the record, there may be things in the record that you believe were done incorrectly that you didn't know about before. And in that case, you need to file a supplemental protest, and that protest needs to be lodged within 10 days of receiving the agency record. Next slide, please. So the next issue is, okay, I've decided I'm going to file, but, what happens next? So the first thing that happens is that the agency needs to file what's called an administrative record or an agency record within 30 days of the filing of the protest. And those are calendar days, not business days. So sometimes you'll see the agency, they usually take the full 30 days, but every once in a while they'll file it early if they think that'll make you have to work, 2 weekends instead of 1, or it cuts your response time a little bit shorter. Before they file the record, the agency has to file what's known as a 5-day letter. And that letter basically says, these are the documents we're going to produce. And these are the documents we object to producing, right? And then you've got 2 days to respond and say why you think that information is relevant and, why the agency, is wrong in not producing it. And then, unless you can come to some kind of an accord with the agency, GAO will decide ultimately what's going to go in that record and what's not. You, the protester, have 10 days after you receive the administrative record to file what's called comments, which is basically your response to what's in the administrative record. So it typically, again, the administrative record typically contains a contracting officer statement, a memorandum of facts and law, and then the documents that are relevant to the protest. And probably the heart of every record is going to be the evaluation documents, whether they are, you know, the memo memorializing the reasons for the decisions. So, you know, that's where you're going to be focusing when you're looking at both responding and also whether you have a supplemental protest to file. What I've seen happen more and more, I don't know if the other panelists have, is that after GAO gets the comments, GAO may pose specific questions to either the protester or the government and say, I have this question, I'm giving you 3 days to get me a response. And then you, protester, you know, you've got 2 days to respond to that. And sometimes I've seen that dragged, you know, through 3 or 4 iterations, which unfortunately give the agency time to get its act together and hone down to, you know, a good answer for them, and, you know, adds cost to the protester. GAO has 100 business days they give themselves to render a decision. So that's basically a 3-month period. The Court of Federal Claims does not have similar set time limits. Typically what happens is you file a protest, and then there will be sort of an administrative hearing, and you and the government will decide on a briefing schedule, the date for the administrative record, and then the date for your reaction to the record, and the agency gets to reply. So it's not as tight as GAO, and again, good rule of thumb, I think, is that at the Court of Federal Claims, a protest is going to last about 6 months, maybe less, maybe more. You've heard about the reference to the protective order. What that is designed to remedy is the fact that, and particularly in post-award protests, right, you're going to get the awardee's proposal. You're going to get all the evaluation documents, right? And if you as a company see that information, it basically disqualifies you for any future recoms, because you now have all the inside information. So what has developed is what's called a protective order. And it's something that you'll see both at GAO and the Court of Federal Claims. And typically only outside counsel and experts are, quote, admitted to the protective order. And that limits, what an attorney or an expert consultant can share with their client, because we can't share protected information. So as you can imagine, it makes things like brief writing a little bit more cumbersome. You have to be very careful not to disclose protected information. There have been some law firms that will say, share a draft of the brief with their client, saying that there's, we've made the cut, there's nothing in there that's protected. And that's a big no-no. So, you've got to communicate as much as you can with the client without tripping that line of giving protected information that's really specific to the source selection or what the contents of the proposal. Next slide, please. So we talked a little bit about the administrative record and what you should be listening for or looking for. So again, the guts of it will be the memorandum of fact of law and the contracting officer statement or explanation for what happened, and then the evaluation documents, such as the source selection decision document. Sometimes you'll even get the individual source selection folks, notes, or if they were to fill out a form, you'll get that form, and you'll get the proposal of the awardee that you are challenging. And then, sometimes the agency, they'll put in, just tons of duplicates or, things you really don't need to bulk it up. And so, after a while doing these things, you get to know what you really should be looking at and what was, intended just to make the record look bigger. So, again, this is your decision point. Do you go forward or do you just withdraw the protest? And are there grounds for a supplemental protest? Whether you use an expert is, again, up to your discretion. It's sometimes very helpful to have an expert admitted to the protective order if it's an outside expert, because the expert can help explain things to us poor attorneys who don't have much of a technical background or an accounting background. So sometimes you hire an expert just for that purpose. You get them admitted to the protective order, and they never really show up in the protest. They're really there to help the attorneys. In other cases, you have an expert who may submit a declaration or an analysis as part of your response to the administrative record. And I think, in the more really technical cases that involve technology that, mere mortals cannot understand, it's good to have an expert. Same thing with complicated, cost, reasonableness, and realism analyses. It's always helpful to have perhaps an accountant to help you. And with that, I'm going to turn it over to Elizabeth.
Great, thank you. So I think we are going to talk first about how we get to the remedies that Mary Beth and Ed mentioned. There's two primary ways that a protest can be resolved, either at GAO or the court, and that's through corrective action or through a written decision. Corrective action is when the agency decides to voluntarily address an issue in response to a protest. And this can occur at any time during a protest, but it generally occurs either before the agency report or administrative record is due or in response to supplemental protests. There can be a couple other trigger points towards the very end of a protest if GAO or the court is signaling to the agency that they're likely to lose, but those two set points of right before the agency report or soon after a supplemental protest tend to be the most common. And agencies have really broad discretion to fashion the scope of corrective action, but it can involve anything from amending a solicitation if it's a solicitation challenge protest, to deciding to do a reevaluation of proposals and make a new source selection. It can involve opening discussions. It can even involve canceling the procurement altogether. And regardless of what action the agency has decided to take, GAO and the court both will typically dismiss the protest if the corrective action moots the protest, which means that it resolves the protest arguments or provides the relief sought by the protester. Written decisions generally fall into three categories: sustained decisions, denied decisions, or dismissals. Sustained decisions mean that GAO or the court agree with the protester on at least one ground, and the decisions do generally outline agreement with particular arguments and disagreement or finding of no merit on other arguments. So protesters will know not just that the protest was sustained, but on what bases it was sustained. And a denied decision indicates that GAO or the court either didn't find that the protester's arguments had merit or that the protester wasn't prejudiced by the errors in the procurement. And a prejudice it really could be a topic of a whole separate webinar, and probably Jennifer has done one of those or will do one of those. But essentially, a protester has to show that but for an agency's improper actions, the protester would have had a substantial chance of receiving award. So there are written decisions where GAO or the court agrees with the protester that the agency made some type of error in the evaluation or source selection, but still denies the decision because the protester wasn't able to show that but for that error, they had a substantial chance of award. So I think Ed mentioned this. I mean, you certainly do see situations where there's a fairly facial error, but the protester is third in line for award, fourth in line for award, and there just really is no possibility that they would have won the award if that error hadn't occurred. A dismissal decision can come early on in the process or even down the line, closer towards the standard time for a decision, but it generally indicates that there was some procedural or technical flaw with the protest. Either it wasn't filed on time or the court or GAO lacked jurisdiction. Protests can also be dismissed because of a lack of prejudice or a lack of interested party status. Occasionally, generally not entire protests, but some protest grounds can be dismissed as overly speculative or lacking a sufficient factual basis. There really are a whole host of bases for dismissal and really something that protesters and their attorneys have to navigate from the very beginning of a protest. Protesters can also elect to withdraw their protest at any time. Mary Beth mentioned this, and it's very common for protesters to ask their attorneys to do a review of the agency report or administrative record and advise the protesters on whether or not there's really any basis to go forward. And I think that determination hinges both on whether or not there's a likelihood that the protest will be sustained or that the agency will take corrective action, and whether or not there's any hope really that the protester will ultimately win the award. At GAO, there is another category of possible outcomes here called outcome prediction ADR. And I think GAO is using this more and more. Essentially how this process works is towards the end of 100 days, when GAO is close to making their decisions, they'll reach out to the parties, ask if the parties are interested, or direct the parties to engage in outcome prediction ADR, where the parties get on the phone and GAO indicates whether, if a written decision is completed, whether they'll sustain the protest or deny the protest and on what grounds. Generally, after that call, the agency will either take voluntary corrective action in response to GAO's indication that they would likely sustain the protest, or the protester will withdraw if GAO has indicated that they likely would have denied the protest. Sometimes GAO actually asks the parties to commit in advance to that call to take that action. Personally, I don't know how the other panelists feel, but it can be a little frustrating sometimes if you're this close to a sustained decision to have a GAO do an outcome prediction ADR. But I think GAO finds that it's a good way to resolve protests somewhat expeditiously. So Mary Beth talked a little bit about if a protester does win, what kind of relief are they likely to get? At GAO, they are making recommendations that an agency fix an error that resulted in a sustained decision. So again, this can mean anything from amending a solicitation to doing reevaluation. It can mean reopening discussions and allowing revised proposals, really anything within the scope of the agency's discretion, which is quite broad. And GAO's recommendations are not binding on the agencies, but an agency is unlikely to ignore a GAO recommendation. It's relatively rare. They have to report those decisions to ignore a GAO recommendation to Congress, and a decision to ignore a GAO recommendation is very likely to trigger a Court of Federal Claims protest. So agencies are aware of that. The possibilities of outcomes at the court are practically similar, although theoretically the court has much broader discretion to fashion the appropriate relief. They can really award any relief that they deem proper, and that includes declaratory and injunctive relief, like directing an agency to stop performance of the awarded contract and perform a new evaluation, or monetary relief like bid and proposal costs. We can go to the next slide. Okay, so here we're talking about appeals and what I put in quotes, appeals. Protesters that have filed an agency level protest that's denied can file a protest at GAO. This is not an appeal really, but it is a new protest on the same basis at a new forum. There are no appeals from GAO since it is an administrative agency rather than a court, but GAO does allow parties to file what they call requests for reconsideration of a decision. To obtain reconsideration, the requesting party, which generally is the protester, but occasionally can be the agency, has to show that GAO's decision contains some error of fact or error of law, or they can try to present information that wasn't previously considered. These requests are very rarely granted. I mean, very, very rarely. So, really not advisable, although you'll see a fair number of requests for reconsideration coming through anyways. As long as the Court of Federal Claims has jurisdiction over a protest, an unsuccessful protester at GAO can file what's usually called a second bite at the apple protest at the Court of Federal Claims. And this is kind of analogous to what I mentioned with taking an agency protest that was denied and going to GAO. Similarly, it's not an appeal, it is just a new protest on the same basis in a different forum. So generally, the court is reviewing the agency action that the protester is challenging, the error in the procurement that's being alleged. They're not reviewing GAO's decision in a kind of appellate manner. So while I say that, I'll note that the court does sort of recognize that GAO is an expert forum in bid protests. And so they do give what they call due regard to GAO decisions. It's not really deference in the legal sense, but it can mean that it's slightly harder to win a protest at the court that has already been denied by GAO. So that's something to consider. I mean, clients do tend to have to weigh whether or not they want to go directly to GAO, knowing the option to go to the court will ultimately still exist, or whether they want to go straight to the court. And a lot of that tends to come down to cost considerations and whether or not they're the incumbent. Incumbents tend to be willing to have a protest or several protests drag on longer than a protester that's not currently performing. Court of Federal Claims protests can be appealed to the United States Court of Appeals for the Federal Circuit, and decisions by the Federal Circuit can be appealed to the US Supreme Court. So this means that the Supreme Court can and has reviewed elements of bid protests, although I would say almost always, but really always, deciding some issue of law, and then they will remand the protest back to the Court of Federal Claims for a new decision that applies whatever the Supreme Court's ruling in that way. So they're not actually making the decision about whether or not there should be a new evaluation or a new award or an amendment to a solicitation. They tend to be settling some question of law, and the protest will then be sent back to the Court of Federal Claims. You can go to the next slide. Okay, so one of the key questions that protesters tend to have is, if I win, can I get my money back? Generally, if a protest is sustained at GAO, GAO will recommend that the agency reimburse the protester the costs incurred of filing and pursuing the protest, which does include attorney's fees. If the protest is resolved earlier than at the sustained decision point, meaning that it's dismissed after the agency takes corrective action, the protester can generally still be awarded its protest costs or some of its protest costs if GAO determines that the agency unduly delayed in taking corrective action in the face of what's called a clearly meritorious protest. So there's kind of two categories there that have to be dug into. One is what is undue delay and what is a clearly meritorious protest. And both those questions are fairly complicated, but a good rule of thumb is that if the agency files a response to a protest allegation that was ultimately meritorious, rather than taking corrective action prior to submission of response, that is undue delay. So that is why so many corrective actions are taken prior to submission of the agency report. Agencies know that if they take corrective action prior to submission of the agency report, they will not generally be required to reimburse the protester their costs. Protesters can request that GAO make a recommendation regarding its entitlement to protest costs. And then if GAO does make that recommendation, they file a claim directly with the contracting officer. If they're not able to resolve that claim through negotiation at the contracting officer or the business-to-business level, then they can go back to GAO for a recommendation on the quantum of entitlement. The court does not award protest costs in the same way as GAO. There's a statute called the Equal Access to Justice Act, EJA, which authorizes the court to award attorney's fees and expenses to really a small class of protesters, and that's those with a corporate net worth of $7 million or less and fewer than 500 employees. So if that doesn't limit recovery enough, in most cases, protesters who got corrective action are not considered to be a prevailing party, and so there's no ability for them to recover under EJA. There's further a statutory cap on the amount that protesters can recover. Attorney's fees are capped at $125 an hour. And while the court does sometimes bump that up for inflation, given that that number was established, I believe, in 1996, the amount really rarely comes close to the market hourly rate for protest attorneys. So in essence, the vast majority of Court of Federal Claims protesters will end up covering their costs or almost all of their costs, regardless of whether or not they prevail. So I think I kick it back to you now, Jennifer.
Great. Thanks so much, Elizabeth, Ed, Mary Beth, and Josh for a great content overview. So now we're just going to dig into some questions. And if anyone from the audience has any questions, there is a control panel on your right-hand side. So just navigate over there and type in your questions. Everything is anonymous, so we're not going to read off your name or your company name. You can just type in your question and one of our panelists will answer. But first we have a couple questions that they're going to answer here directly. And Mary Beth, the first one is for you. How often does GAO hold hearings?
I think that's a dying practice. There are fewer and fewer every year. I think the last couple of years, maybe there were 2. I think what has replaced it is those sort of iterative questions that the agencies might ask. And, you know, even before these times, there still were not very many hearings held. And they typically revolved around very technical issues. The last one that I had, which was many years ago, was a NASA protest, and the technology that was under, you know, that was the issue, really needed, you know, more explanation than I think briefs could convey. But generally, you're not seeing them very much.
Okay, great. And Ed, do I need an attorney to file a protest?
I guess the question is need versus want. You don't necessarily have to have a lawyer if, for example, you want to protest to the agency or the GAO. You do if you want to go to the Court of Federal Claims. My recommendation, however, would be to always consult with an attorney who understands the sorts of issues that you're dealing with, so that you have some assistance, number one, in formulating the correct arguments to make. And then number 2, if there's a protective order in place, for example, at the GAO, and you don't have an attorney that's assisting you, then you're going to be at a distinct disadvantage as the protesting party, because you won't have full access to all the information that you'd like to see for purposes of making your arguments. So while you don't necessarily have to always have an attorney, you probably should.
Okay, great. And Josh, what are Department of Defense, hang on, my screen is, what are Department of Defense enhanced debriefings? Maybe you're on mute.
That's a good question. So for folks who are dealing with a procurement that is a Department of Defense procurement, from the 2018 NDAA, we have some new rules with respect to debriefings. And in those situations, the unsuccessful offeror would have 2 business days to ask additional questions following the debriefing date. The agency would have then 5 days to provide a written response. Now, interestingly, I think many protesters counsel recommend that their clients ask questions, but every now and then a client or a company decides to not ask questions. And the question was sort of unresolved until this year as to what would happen when a contractor didn't ask the questions. Was the debriefing date the date that they received the debriefing, or did the 2-day window extend it? And Nika Technologies, the court, which went up to the federal circuit in an unusual manner, which was appealed by the government, and the protester did not participate. The court ruled that the debriefing date was the date that the briefing was held, not this extra 2-day window. And so for folks who are dealing with DoD procurements, regardless of whether or not the agency makes it known in their email, sometimes they'll put you on notice of, hey, if you want to ask additional questions, you have 2 days to do so. But that may not always be the case. So if you're dealing with the Department of Defense, know that you have this option to ask, and that's under 10 U.S. Code 2305. Interestingly, though not put in regulation yet, contractors have an opportunity to ask for redacted source selection or for procurements over 100 million. And if you're a small business and the procurement is between 10 and 100, you have the option to request it. And then interestingly, again, a written or oral debrief for all contracts and awards and task and delivery orders of greater than or equal to 10 million was also provided in the NDA of 2018, although those have not yet been put into the DFARS. But something to remember if you're dealing with DoD, you have enhanced opportunity to ask these additional questions, which is highly recommended to do so.
Great, thanks. And Elizabeth, can you protest an agency's decision to take corrective action or the scope of the planned action?
Yes, either. And it's been an interesting couple years in determining what exactly is the standard against which the agency's decision is going to be judged. There was a decision that went up to the federal circuit a couple of years ago. I think it was 2018, Adele Federal, where the federal circuit indicated that protest of an agency's corrective action will be evaluated using the standard rational basis test. That's standard before the Court of Federal Claims. So the question there is whether or not the scope of the agency's corrective action is rationally related to the alleged defect that was brought forth in the protest. The Court of Federal Claims had sort of kicked around the possibility of a standard that the corrective action had to be narrowly tailored to the alleged defect. That actually brought a lot of protests. It's common for an agency to take corrective action that is not narrowly tailored to the alleged defect. I mean, sometimes the alleged defect is, a minor evaluation error, and the corrective action is cancellation of the procurement. It's hard to argue that action is narrowly tailored to the defect. So now that we're back to a rational basis, I think we've seen fewer corrective action challenges, and it can be a harder hurdle to get over. But if there is a situation where there is something wrong with the corrective action, or if it's really out of bounds of the scope of the alleged defect, then you do have that possibility to take those protests either to GAO or to the Court of Federal Claims.
Okay, great. Mary Beth, back to you. Can in-house counsel be admitted to the protective order?
The answer to that is very, very rarely. And the reason is, in most instances, attorneys in-house have some input into the proposals that are going out of their shop. And the standard is you have to have, in order to be admitted to the protective order, you have to have no role in competitive business decisions about bids and proposals, right? So unless the attorney is completely isolated from the bid and proposal effort, they will not be admitted into the protective order. And it's been a long time, at least in my experience, since I've seen an in-house counsel be admitted.
Great. Thank you. And Ed, what are my chances of success?
What every client wants to know. It depends. There's your lawyer answer. So it does sort of depend, right, on the facts and circumstances and the legal issues that are raised as part of any protest. If you want to look at effectiveness, the best place probably to look is to the GAO. Every year, the GAO issues a report to Congress, which provides an effectiveness rate. As part of that effectiveness rate, the report will take into consideration the number of times that the GAO sustains a protest, as well as the number of times that an agency will take corrective action in response to a protest. So what's interesting is the effectiveness rate has been going up. At the end of 2020, in December, when the report came out, the effectiveness rate from GAO was 51%, which is really high. So what that means is that 51% of the time when a protest is filed, either there's corrective action that's taken place, or you have a decision where the protest is sustained. The vast majority of that 51% is corrective action. I don't recall exactly what the sustain rate was at the end of last year, but I suspect that it was fairly low, probably in the teens somewhere. The rest of that is made up of the corrective action taken by the agency. So that'll give you at least some indication. The Court of Federal Claims doesn't issue similar data, but that'll at least give you some indication as to what the chances are of success.
Okay, great. And Josh, can a contractor receive a debriefing if it misses the 3-day deadline or in a procurement that isn't under FAR Part 15?
So the simple answer is yes. Even if you miss the 3-day deadline, the agency may still give you a debriefing, but in that instance, the debriefing isn't, quote, required under the FAR. And that's important because it, as I mentioned earlier, may have an impact on what day that you're able to file the protest and satisfy the timeliness rule. In terms of receiving a debriefing that isn't under a procurement conducted under FAR Part 15, that is a little bit more of a nebulous question. There are some FAR Part 12 procurements that invoke the procedures under FAR Part 15, and those often will turn to the facts of a specific solicitation. But if you're dealing with a negotiated procurement under FAR Part 15, or as I mentioned earlier, a task or delivery order over $6 million, subject to FAR subpart 16505, then that should be your clue that you'll receive a debriefing. 4.4 by, for example, if you're under an 8, you're going to be receiving a brief explanation in most cases. So, even though you may actually request a debriefing, as I mentioned, it's sometimes thrown around as a colloquial term, but it is technically a term of art here.
Okay, great. And Elizabeth, sorry, my screen. When can I recover bid and proposal costs?
So people ask this question a lot, and my answer is generally you don't want to, because it probably means that you're not getting the relief that you actually want, which is a type of relief that will ultimately get you a chance at winning this contract. So both GAO and the court tend to award bid and proposal costs when there's no other effective remedy. There are two situations that this tends to happen in. One is the contract is already over. This happens at the Court of Federal Claims, sometimes with short contracts and drawn out protests. If the protest is sustained, there's nothing that can be done. There's no reevaluation, there's no reaward, there is no remedy for the protester. So in that case, it's common for the court to say that the protester can recover their bid and proposal costs in addition to whatever protest costs that they can recover under EJA. Mary Beth mentioned another not uncommon situation where this can come up, and that's for a lease procurement that does not have a termination for convenience provision. GAO does not feel it's within their authority to recommend that agencies breach contracts when they cannot terminate them for convenience. So in that situation too, GAO will generally recommend bid and proposal costs. So it's very, very unlikely for a protester to both get the remedy that they want in terms of something that will allow them to ultimately compete fairly for this contract and B&P. So I say you should not shoot for B&P.
Okay, great. Okay, and I think this is going to take us then to our live questions, and I believe we have a couple that have come in here. Again, if anybody does have questions, please go to the menu on the right-hand side and type in your questions. They are all anonymous. So the first one, if a government awards a bridge contract to the incumbent, which changed the inventory level, which was published by the government to calculate shipping prices, can the bidder request the government to allow revision in submitted pricing? If the government does not allow it, would this be a case for protest? And whoever wants to answer, I'll let you guys decide amongst yourselves.
I think the question is from an incumbent asking if they can protest a change that the agency has made in their contract during the bridge period. I think that's what the question is. In that case, that would probably be more appropriate for a REA or a claim than for a protest, but maybe I misunderstood. Did anybody else perceive that question differently?
No, I think that's the way I heard it as well. I think one of the things that we all deal with from time to time is this whole notion of, is it a situation where you submit an REA or a claim, or is it something that's protestable, right? So that could be, that's sort of circling in my mind too. When I heard that, I agree that I think in a situation as it was described, the way to go would be through the REA or the claim process. Yeah.
Great. Okay.
And really that line in the sand, sorry, that line between protestable and REA versus claim tends to come down to whether it's a matter of contract administration. So changes that occur after award during performance that deal with whether or not the agency has made a change or constructive change to the contract, or that there's some sort of change in expectation of performance, that puts you in the world of REAs and claims versus challenges to how the award decision was conducted and how the procurement was established and made, the contract was formed. Those are in the world of protest.
Okay, great. And the next question reads, let's say you are protesting an award that did not meet the published silent characteristics, but the agency uses the protective order to shield this act, i.e. whether the awarded solution meets or does not meet the salient characteristics is redacted. Have you seen this deflect strategy or other abuse of the protective order from agencies?
I haven't seen anything that sort of egregious, but I certainly have seen instances where you may not have gotten all the documents that the agency has. And very often, one document in the record will, refer to a March 10th memo, and that March 10th memo is not in the record. But typically, if it is germane to the protest as to whether or not the agency evaluated the salient issues and what the result of that evaluation is, you should see that in the record. And if you don't, that's certainly something that you want to raise to either jail or the court. Because the standard is they really have to give you everything that is relevant to the protested issue.
Okay. And the next question reads, the awardee and the agency have the same interest, denial of a protest. Have you seen agencies not proceed impartially and enlist the support of the awardee to help them defeat the protest. What can the protester do if they see this happening?
That's expected. It's called intervention. So it's, they are in cahoots. That's well said. Their interests are aligned, and it's appropriate and expected under the GAO procedures and Court of Federal Claims procedures that interveners, counsel, and agency can work together to defend the award.
Yeah, I had an argument yesterday with GAO on we challenged proposed corrective action, and there was an intervener that was involved, and the argument was comprised of agency beating up my arguments, intervener beating up my arguments, and me trying to sort of defend against both, right? And as Elizabeth said, that's the sort of thing that happens commonly, where you have an intervener, when you have one, assisting the agency in defending the award.
Great. Okay, and the next question, in a recent solicitation, our past performance rating was given acceptance when the references all marked outstanding in all of the questions, which made us lose the contract. Only one question in all 3 references, total 30 questions, was marked above average. They are counting this acceptance level. Can you comment on this issue? Just trying to understand how a protest might help here.
Yeah, I think in that situation, what we would look at the definitions that were established either in the solicitation or by the technical evaluation board for the various adjectival ratings, and try to match up the adjectival rating that you received versus those definitions that the agency established for themselves. So often they'll say that certain past performance adjectival ratings could result in X evaluation adjectival rating, or that you have to have some sort of weakness or low rating in the past performance evaluation in order to justify an evaluation adjectival rating. So it's hard when you're just talking about complete deference in assigning adjectival ratings, but sometimes there is something concrete in the solicitation or that the agency has otherwise established that we can use to try to get a valid protest.
Great. And we've got some clarification on that first question that came in, which was if a government awards a bridge contract to the incumbent, which changes the inventory level, which was published by the government to calculate shipping prices, can the bidder request the government to allow revision in submitted pricing? If the government does not allow it, would this be cause for protest? And then I think you guys were trying to understand some additional information. So the questioner clarified they haven't awarded the contract to a new company yet. They gave the bridge to the incumbent and delayed award. I don't know if that helps answer the question any further. Anything you want to add to what you've already responded to on this one?
Is the question, there's been a contract award, the agency is going to issue a bridge contract, rather than going out to compete, but the bridge contract differs in material ways from the underlying contract. Could one of the initial protesters or initial awardees protest the bridge contract and say it's so different, it should have been competed?
I think that's how the question is reading, yes. So inventory levels have changed. Obviously that was going to impact the shipping prices. Can the bidder request the government to allow revision in submitted pricing? And if not, can they protest?
I think to clarify, I think what folks have been talking about here, this sounds highly fact specific because you're dealing with an unfortunate situation I think happens a lot, which is you have information from a bridge contract, which is separate from an underlying procurement. and whether or not the information here would impact how you bid here. Yeah, I'm having a hard time conceptualizing it beyond that, and probably would need a little bit more details to kind of to have a more concrete answer. But typically, when you're challenging a procurement, it's the government is making its evaluation based on the evaluation factors and methodology that they set forth in the solicitation. But you know, that doesn't mean that there isn't a remedy that you can look to. I think what Elizabeth and Ed were saying earlier about whether it's a protest or an REA, it sounds like you're not the incumbent, but you're bidding on something. So you're in a hazy area that I think it's a little bit challenging to answer that in the webinar, unfortunately.
It's possible that if the argument is that the bridge contract indicates that the existing solicitation doesn't reflect the agency's actual needs, that is a valid pre-award solicitation challenge protest ground. But the reality of the situation is that unless the agency takes corrective action, you have little chance, because the agency gets to they get to establish their own needs. So if they come back and say, you know, here was the reason the bridge contract quantities were different than the underlying solicitation quantities, then that is likely going to fly, you know, either at GAO or the court. They would just need to have some explanation for the difference there.
Okay. And another question here. The question is, an RFP was released and proposals received. Sorry, hang on one second. I think another question jumped in front of that. Okay, bear with me. The question is, an RFP was released and proposals received, then the government awarded a bridge to the current incumbent. The RFP was asking for pricing of, say, 2,000 pieces, but the bridge is using 500 of those. So the open RFP proposals already submitted was going at 2,000, which is cheaper than 500. Can they ask the government to amend the RFP to the 1,500?
Yeah, I think this is what I was getting at. You could say that there's something about the bridge contract that indicates that the solicitation doesn't reflect the agency's actual needs. But you know, the agency is saying what their needs are. So I think maybe that's worth a a solicitation Q&A or an email to the contracting officer, maybe an agency protest to try to get to the bottom of what the difference is there. But agencies really have a tremendous amount of discretion to establish their own needs.
Great. Okay, and our last question here reads, in November 2020, SBA revised its policies towards small business joint ventures such that joint ventures do not need to have a facility clearance so long as the small business prime has a facility clearance itself. This makes extreme sense since the JV is unpopulated and it is the two joint venture members doing the work. However, DCSA has indicated it will not follow this change until it comes out in DFARS, FARS. On what grounds would you potentially do pre-award protests if the joint venture FCL is a material requirement of the solicitation? Anybody?
I mean, I think you can certainly argue that it is an unreasonable restriction on competition, right? Because you are leaving out all of the JVs out there that don't have a facility clearance or can't get a facility clearance. This has sort of been a running battle between DOD and SBA for a while. I'm not aware of any protests that have been filed on that basis.
Okay. And actually one more last one and then we'll wrap up here as we're coming around to 1:30. DLA has a solicitation where you email your proposal, somewhere you enter in dibs online or both. Can the agency deny a quote received timely via email by the contracting officer because it was not entered online.
That is an unfortunate situation that I think happens a lot. There was just a recent protest where a protester had to enter a bunch of CLINs and GSA, I think it was, or some sort of online mechanism, and upload their proposal. But unfortunately, they weren't able to click the submit button. And even though they had emailed the agency, they kind of were not evaluated on that basis. The late is late rule is an unfortunate thing that kind of trips up a lot of contractors. Depends on what the solicitation says. If it allows for email, or if it is required only to be inputted into that system. I think similar to what Mary Beth was talking about with respect to the joint venture issue that's been a big issue for a lot of contractors, is that late is late rule. You see some cases at GAO and some other cases at the Court of Federal Claims that have perhaps not always been parallel with, and it really depends on the language of the actual RFP or an RFQ, which technically related, unless invokes a 212 clause, wouldn't have. But unfortunate, but I think it depends on the language of the solicitation. I don't know if anyone has any other comment beyond that.
I mean, late is the rule that we all go by. And actually, the Federal Circuit just issued an opinion that was that came out today or yesterday that reiterated the whole late is late rule that we all understand. But the facts were a little bit different in that case, and in that case, the agency extended the proposal submission period by a day and did so via email. Unfortunately, not everybody got that email. I guess that was part of the problem. But at the end of the day, what the Federal Circuit indicated was that, look, the agency has a discretion to extend proposal deadlines. Yeah, late is late, but what late means is at the discretion of the government.
Great. Okay. Thank you guys, all of you, Mary Beth, Ed, Elizabeth, Josh, for great content. Thanks to all of the attendees for logging on today. You will receive the PowerPoint slides and the MP4 probably later this evening. You've got contact information here for all the speakers. Just keep in mind, Mary Beth has retired, so you probably want to direct your content and your questions to Ed, Elizabeth, and Josh. And please join us next month on April 19th as we cover teaming agreements. May is subcontracting, June is sales and capture. The rest of our topics for the following month are listed here. And thanks again, everybody who joined us today. And that concludes our presentation.
Thank you.
Thanks,
Thank
everybody.
you.
Bye, everyone.
Bye.